Well, welcome back. Mr. Osima Jina joins us now. He is a member of the Judicial Service Commission in Rivers State, also on the team of the PDP. Morning, and thank you for coming on today.
Good morning.
Well, looking at that judgment, wherein the court did say that it did not comply substantially with the provisions of the Electoral Act, and your party pretty much disappointed in this one. But looking at the facts of that case, what's your response to that?
Well, first, let's look at the tribunal itself, the panel, because I happen to be from the beginning. We have 3 members set up by the president of the Court of Appeal. It has Honorable Justice Pingida, who is the chairman, and also have Justice Wesley Ibrahim Leah and Honorable Justice Bayo Taiwo. Now, it is interesting to know that the tribunal sat first on the 11th of June. I was in court on that day. And the 11th of June was when an ex parte order was granted in favor of APC for inspection of INEC documents. Now, that was the beginning of the sitting of the governorship tribunal in Rivers State, sitting at Abuja. Now, after that, PDP and the candidate, Wike, made several applications, and they were all turned down. Even the application to set aside the ex parte order was turned down by Honorable Justice Pingida-led panel. Now, but at the point in time, there was an interesting note. One application, just one application, that was refused by the Honorable Justice Pingida-led panel as chairman, made him to be removed.
Which application is that?
Now, that application was application for forensic inspection. And the chairman observed that he has already made an order for inspection. And so he cannot make another order for forensic inspection. In fact, he explained that his earlier order also included an inspection, forensic inspection.
Is that the petition that they said was written against him, which
No. There was no petition. Nobody wrote a petition against him. And that's why we are surprised. Take, for instance, when in panel 1, when Honorable Justice V. Okore misbehaved, a petition was written against him. And because he was found to be guilty of it, he was demoted from a chairman to an ordinary member in panel 3, Jabi, sitting at Court of Appeal Jabi.
How did that affect the judgment?
Now, that did not affect the judgment. But what we are saying is that now the Pingida was removed and taken to panel 2 in Jabi. Now, and Ambrusa was brought in as chairman in the National Assembly and House of Assembly election petition to head the governorship election petition.
Is there anything wrong with that?
Yeah, there's something wrong in it. Now, if you, first, what is the complaint? Because we asked the panel. Even APC denied that they never wrote any petition against the chairman. So who complained against Ambrusa? No, who complained against Pingida that you remove him from a panel and move him to another panel and still retain him as a chairman? And so there is everything wrong in it. Now, it gives us the impression that something somewhere is fishy. Now, when the new chairman came in, he started sitting. Now, and the first thing that came before him was the issue that before he came, the tribunal has already taken the report. Now, and in that report...
Which report is this?
Now, the report is that at the end of pretrial, there's what we call a pretrial report. The tribunal will turn a pretrial report and give direction on what to do, how evidence will be called, and if there are applications still pending to be taken. Now, there were applications pending to be taken. But before then, let me explain how we move. Now, is it on the 29th of July, 2015, a motion challenging the tribunal jurisdiction were taken by then Pingida. Now, that ruling was not delivered. He rather delivered a ruling on the 31st of July to say that he would deliver his ruling alongside with the main petition. Now, there was appeal against it because we are challenging the jurisdiction of the petitioner himself, whom we observe that is not qualified to contest, and therefore he is not also qualified to bring an election petition to challenge the success of Governor Wike.
Who was supposed to rule on that, Justice Pindiga?
Yes, it was supposed to be ruled by Justice Pindiga. Now, but Justice Pindiga at that time did not give the ruling. So we went on Court of Appeal, and Court of Appeal directed that the tribunal must deliver its ruling. And so now we are in a fix because a new chairman has come in. Now, can a chairman who did not hear an application give a ruling? Which is no. Because
did your party kick against the
yes.
chairman when he came in?
Yes, we kick against it.
Was there a petition?
No, there was no petition. But we all rally because it's a legal process. And we are lawyers. Now, what we first ask, and APC denied. And so we all rally. The lead counsel, EC, Okala, SAN, all rally, question the rationale for removing Justice Pingida and bringing Justice Ambrusa to head the panel. Now, he raised the issue that Ambrusa cannot deliver a ruling that he did not take argument. And you know that Section 27(1) of the Electoral Act, by Section 27(1), now he cannot do that. Section 27(1), first schedule of the Electoral Act, all interlocutory applications to be heard and disposed of by the chairman. Now, the operating word there is heard. So a new chairman came in, he did not hear the application, but he disposed of it. Now, the argument some people will advance is that he didn't dispose of it, but he signed on record as chairman would deliver that ruling. And so that is wrong in law. Now, going further, they will see that a chairman who did not hear a matter cannot deliver a ruling, which I've said it. Now, we are questioning there the authority, the locus classicus of Dakuku Peter Side himself. Because if you go by Section 2854 of the 1999 Constitution, you see that the quorum of election tribunal is chairman and 2 other members, which is also in the 6th schedule, B21 of the 1999 Constitution. Now, 2 members were there who had that application. Now, the 3rd man, who is the chairman, does not constitute a quorum because he never had that application, but he ruled on it. Now, EDP also brought in an application, which he also ruled on it because the tribunal, the Court of Appeal directed that the tribunal should deliver a ruling.
So is it that he didn't hear the matter at all and gave a ruling, or he concluded hearing and then gave a ruling?
He didn't hear the matter. He gave a ruling. He gave a ruling. Now, the only application which he took himself was the application challenging the locus classicus, challenging the jurisdiction of the court to entertain the petition, and that Dakuku Peter Side is not a candidate. Is not qualified to bring the petition. Is not qualified to contest the election because his party did not give a minimum 21 days to INEC. Because it is the law under Section 85 that he will give minimum of 21 days to INEC, Section 25 of the Electoral Act. Now, APC gives 16 days notice, and 16 days notice is short of the 21 days. Now, there were similar applications that were made, SDP and Wike, Labour Party and Wike. Now, the same tribunal ruled in those matters that because the 21 days were not reached, that they have no locus.
Okay.
Now, but in APC matter, the tribunal did not rule. Now, the new chairman, when he came in, ruled that it is a pre-election matter. Now, but before then, let me come in. We have Supreme Court authority. We have Court of Appeal authority. Now, and in law, there is what we call stare decisis under Section 287 of the Constitution. You must, it's mandatory, you must obey the judgment, you must enforce the judgment of a superior court. Now, when a Court of Appeal and Supreme Court has delivered judgment. A lower court has no reason to depart from it, particularly court of first instance. But the tribunal under Ambrusa did not give reason, did not make any reference to any judicial authority. Then on its own, departed